Now, the next topic is humanitarian intervention. We'll learn about what is intervention and particularly what is humanitarian intervention. What is intervention or a humanitarian intervention? What are its kinds? And is it legally justified under international law? That is what the question is. What are the circumstances under which it is legally justified under international law? Because there can be a intervention, it can be with a very good intent of mind, but it cannot be very legal. For intervention to be legal, to be legally justified, that particular intervention has to have a sanctity of United Nations, because that is the international body we are having. So there is a charter of UN called UN Charter. It gives some kind of a condition where a country can have a intervention, and in that and only that cases there can be an intervention. No other cases there cannot be any intervention. So if the cases falls under that particular category, the intervention would be legally justified. You may be hearing that America has intervened in many countries. There can be a punitive kind of a intervention, or sometimes it does happen. For example, in Iraq war, it directly went inside the country. So there can be external intervention and there can be internal intervention. For example, in Libya, the NATO and US, what they did, there was infighting and they held a party in infighting. So intervention can be of three kinds, and there can be the intervention to be legal has to have sanctity of UN. इंटरवेंशन को लीगल होने के लिए यूएन की सैंक्टिटी बहुत ज़रूरत है, उसके चार्टर की सैंक्टिटी बहुत ज़रूरत है. तो सबसे पहले हम चलते हैं, लेट्स अंडरस्टैंड द डेफिनेशन ऑफ टर्म इंटरवेंशन. नाउ इंटरवेंशन हैज़ बीन डिफाइंड बाय ओपेनहाइम एंड प्रोफेसर क्विंसी राइट. देयर आर टू पर्सन्स. वन इज ओपेनहाइम. You will hear his name every now and then, because international law and other law he has got a great contribution. Another is Professor Quincy Wright. So both have defined the intervention. So Oppenheim says that intervention is a dictatorial interference. So what kind of interference? It is a dictatorial interference by a state in the affairs of another state. For example, the US is a state, is interfering in Iraq at the time of Iraq war. So it is basically a dictatorial interference by a state in the affairs of another state, and there is a purpose. What is that purpose? The purpose is maintaining or altering the actual principles of things. This was defined by Oppenheim. So Oppenheim says it's a dictatorial interference by one state to another state, and the purpose is maintaining or altering the actual principles of things. In principle, international law prohibits intervention. UN prohibits intervention. In some cases it allows, but generally it prohibits intervention. But as pointed out by Professor Carlsen, he says international law does not prohibit intervention in all circumstances. Means there are certain circumstances where intervention is legally possible, is legally justified. Now the Professor Quincy Wright says intervention can be diplomatic as well as military. There can be a military intervention or there can be a diplomatic intervention. There can be a diplomatic communication of preemptory or threatening one, implying possible use of military or other coercive method may constitute intervention. So in a diplomatic intervention, there can be a diplomatic communication, or preemptory means there can be a threat. A state can convey a threat that they can possibly use a military or other coercive measures, this threat may constitute intervention. Now there is a charter, UN Charter. UN Charter, there is a Article 2(4). Article 2, the subsection 4 of that Article 2 says, all members shall refrain in their international relationship from threat or use of force against the territorial integrity or political independence of any state or in other manner inconsistent with the purpose of UN Charter. So, if there are members of UN members, so in their international relationship, they will not use threat or use of force against territorial integrity. Means you cannot territorially violate another country, because if you territorially violate another country, there would be a war, and they want to prevent all kind of a war. Not only that, political independence of any state cannot be, there cannot be threat to that. You cannot give threat to that. You cannot use force for political independence of any state, or you cannot give threat, or you cannot use force in a manner which is inconsistent with the purpose of UN Charter. So there are three things which is prohibited by UN Charter 2 subsection 4. Use of threat or use of force. Neither you can threaten nor you can use force for three purposes. The first one is violation of territorial integrity. Second is creating problem with political independence of any state. Third is any purpose which is inconsistent with the UN Charter. Now there is a principle of non-intervention by United Nations. Means most of the state won't intervene. There would be a policy of non-interference. Means a country will non-interfere in the affairs of another country, and this has been provided in Article 2 subsection 7. This Article 2 subsection 7 of UN Charter provides that nothing contained in present charter shall authorize UN to intervene in the matter which are essentially within domestic jurisdiction of any state. Means if there is a domestic jurisdiction, or if a country it is having domestically whatever it is doing domestically, the UN or any members cannot interfere in it. There is a principle of non-interference. This is what it is over there. So it is against, you cannot intervene. There cannot be an intervention. Only except certain cases there cannot be any intervention in the internal affair of any country. Or if there is any internal matter, the UN cannot force that internal matter to be brought to UN for its settlement. So it is said that the principle of non-intervention by UN Charter says that internal matters, in case of internal matters, the UN cannot intervene. Not only that UN cannot intervene, it cannot force a state to bring the matters to UN if it is related to its internal matter. But this section, but this article, but this principle, it will not prejudice the enforcement measure in Chapter 7. In Chapter 7 there are certain enforcement measures given. So this principle cannot override that. In Chapter 7 would be overriding on these principles. So generally the UN principle is art of non-interference. The UN won't interfere in the internal matter, neither shall force a country to bring its matter to UN for settlement. And the Article 2 subsection 4 says that there cannot be threat, cannot be use of force against territorial integrity, political independence, or any other matter which is inconsistent with UN Charter. Now the intervention can be made in the following ways. There are areas where intervention can be done. First is self-defense. Self-defense is considered as a valid ground of intervention by one state in the affair of another state for a long time. Now the Oppenheim has said that the use of force in self-defense can be justified only when it is necessary for self-preservation, which means that, so according to Oppenheim, in case of self-preservation, the self-defense is only justified. There was Mr. Webster, he was Secretary of USA. He propounded an important principle in the famous case called the So Mr. Webster declared that the necessity of self-defense should be instant, overwhelming, leaving no choice of means and no moment of deliberation. It means the force should be used in such an overwhelming manner that it would be imperative for self-defense that intervention would be necessary. So Oppenheim, according to Oppenheim, self-preservation is a case where intervention is justified. But that traditional right of self-defense and self-preservation, it stands modified by UN Charter. In UN Charter, there is no word such as self-preservation. The Charter says that only when there is an armed attack, there can be intervention. So when there is an armed attack, there can be intervention. It also recognizes certain other restrictions on exercise of right of self-defense. There is Article 51 of UN Charter. It confers upon every state the right of individual or collective self-defense. But this right is subject to certain conditions. First, there should be an armed attack. The right exists until Security Council has taken any action. If the Security Council takes any action, then the right ceases. This should be reported to Security Council. It is subject to review by Security Council. The right shall not affect responsibility of Security Council for maintenance of peace and security. The maintenance of peace and security of the world is a paramount duty of Security Council. That is why it is made. And it is the responsibility of Security Council. This right should not violate that particular right. And this right is not available against the non-member of UN. So Article 51 of UN says that every state, there is a right of individual or collective self-defense. Means if a country is fighting with another country, or it is fighting with two countries or three countries, there is a right of self-defense with other countries. They can collectively self-defend, or they can unilaterally self-defend. But there should have been an armed attack. First, if somebody else has attacked, then only question of self-defense arises. If Security Council acts, then this right ceases. Right of intervention ceases. It should be reported to Security Council. It should be subject to review of Security Council. It should not go against the right of Security Council to maintain peace and security. This right is not available to non-members. The second important area is intervention on humanitarian ground. The Security Council has intervened when it was permitted on humanitarian ground. There is a huge history behind it. England, France and Russia jointly intervened in conflict of Greece and Turkey in 1827 so as to prevent the violation of human rights. In 1860, intervention was made in favor of Christians of Mount Lebanon. In 1878, intervention was made to protect the independence of Balkan states. So, a natural question arises whether intervention on humanitarian ground is permitted under UN Charter or not. The preamble of Charter reaffirms faith in human rights and fundamental freedom. Articles of Charter declares that international cooperation in respect of human rights and their development is one of the purposes of UN. So one of the purpose of UN is international cooperation, where international cooperation should be in respect of human rights and their development. So it promotes human rights and it encourages cooperation between nations in regards to that. And there is a Article 55 and 56 of Charter. The member have to undertake the responsibility of taking collective action in this regard. So there is a place of significance which is given by United Nations to the development of human rights and freedom. In 1948, the General Assembly of UN unanimously adopted the Universal Declaration of Human Rights. It was unanimous adoption, and also adopted the Genocide Convention of 1948. Further, Convention on Children, Women and Prohibition of Racial Policy have been adopted. Finally, 4 international covenants on human rights have been signed in 1966. These conventions are generally reckoned as International Bill of Human Rights. They have now come into force. They clearly indicate international trends and practices of state relating to human rights. Now, if there is a violation of human rights, can UN intervene? No, UN cannot intervene only in the case if there is a human right violation alone. The human right violation should be so grave that there should be threat to international peace and security. So there are 2 things which should come in: violation of human rights, and the violation of human rights in a member state possesses a threat to international peace and security. Then only under Chapter 7 UN can take action. Unless and until Security Council first determines that there is a violation of human rights and it possesses a threat to international peace and security, actions under Chapter 7 cannot be taken. Thus, the ground of human right alone cannot act as a violation or intervention in affairs of member state. So there is a art of non-interference. There is a non-interference, principle of non-interference, and the intervention can only be happen when there is a threat to international peace and security and there is a violation of human rights. The intervention, third point, is to enforce treaty rights. This was a valid case in past, but now in the presence of UN Charter, this has ceased to be a valid ground for intervention, because enforcement of treaty rights, you cannot have an intervention. There has to be a threat to international peace and harmony and security. Now, fourth point, intervention to prevent illegal intervention. If there is an illegal intervention, can you intervene? In past, this was a valid ground, but now UN Charter has greatly affected intervention on this account also, because UN Charter says there should be a threat to international peace and security and there should be a violation of human rights. First point is balance of power. Intervention on ground of balance of power used to be a valid ground in past, but no more permissible ground of intervention in the presence of UN Charter. For protection of person and property, the UN Charter also does not recognize this ground and permits intervention only on ground of self-defense. Then there is a collective intervention. The collective intervention is allowed. Self-defense is allowed, intervention of humanitarian ground is allowed, and collective intervention is allowed under Chapter 7. Under Chapter 7, Security Council can take collective action against any state in order to maintain or restore international peace and security. So, to maintain international peace and security, collective intervention is allowed. The glaring example of collective action are Korea 1950 and Congo 1961. Thus, UN can intervene in the affair of any state in order to maintain and restore international peace and security. Eighth point is intervention to maintain international law. No, it is not allowed. because the charter provides that intervention on the ground of maintaining international peace and security, which may come broadly under international law, but no intervention is permissible for maintaining international law as such. If any country violates any international law, there cannot be any intervention. The intervention can be on the ground of maintaining international peace and security. Ninth point is intervention in civil wars. Article 2.7 Charter prohibits UN from intervening in domestic affairs of any state. And as such, ordinarily, UN cannot interfere in civil war of any state. But if the civil war assumes such magnitude that it possesses threat to international peace and security, the key word is international peace and security. If that civil war changes into that fashion that many countries comes in and there is an international peace and security, or by any other reason, if there is a threat to international peace and security, UN can intervene. Otherwise, there is a complete prohibition. There is a principle of non-interference. Enforcement measures which are taken under Chapter 7 are taken by Security Council to maintain or restore international peace or security. Only under Chapter 7 can UN intervene. And they can intervene only when there is a threat to international peace and security. So there are only two grounds. It can be rightly said there are only two grounds, one for member state of UN and one for United Nations, on which intervention is possible under Charter of UN. Member state of UN, the ground, what is the ground? Self-defense. And UN, the ground is international peace and security. Now, what are the kind of intervention? Basically, there are three kinds of intervention. The external intervention, the international intervention, and punitive intervention. External intervention, when a state intervenes in a foreign affairs of another state, it is said to be external intervention. This is equivalent to declaration of war. So, if a state intervenes in foreign affairs of another state, it is called external intervention. Second is international intervention, when two opposite groups are fighting in a state and to support either of the group, another state is called. It is called internal intervention in the affair of by that state. Third is punitive intervention. Punitive method is bit less than the war. When certain damages are done by individuals of a state in reaction to this action taken by other state, it is called punitive intervention. So in punitive intervention, there should be certain damages which are done by individual of state. So we can say Article 2 tells about, to summarize, we can say Article 2 tells about art of non-interference, principle of non-interference. There cannot be interference. Normally there will be a non-interference in a state, affairs of state, in internal matter of state. But Chapter 7 allows UN to interfere. A state can also, there can be intervention by a state in case of self-defense, and UN can intervene if there is a threat to international peace and security. This sums up intervention.